Hello and welcome to this week's Ask an Atheist. I'm Annie Laurie Gaylor, co-president of the Freedom from Religion Foundation.
And I'm Rebecca Markert, the legal director here at FFRF.
Today we are going to talk about 5 things to know about the leaked opinion overturning Roe v. Wade, written by Justice Samuel Alito. Rebecca has suffered through this draft opinion and graciously has written a blog about those 5 things that you should know. And we'll get to that. But first, as always, if you have questions about our topic today, you can drop them in the comments below or send an email to askanatheist@ffrf.org. So, Rebecca, thank you so much for reading this draft, and I understand it was a very difficult assignment.
Yes, it was. So that Monday that the opinion came down, we were just digesting the unanimous decision out of the City of Boston case where there was a Christian flag flown at a request to fly the Christian flag at Boston City Hall. And when we were digesting that unanimous opinion, when that evening this opinion came out. And so it made for a very long evening. The opinion itself is 98 pages. So it's a lot to get through. It's very dense reading, and it's also very depressing. I had to take a lot of breaks for my mental health.
Yes, mental health as well. I have to confess, I haven't gotten through it yet because I just get so mad when I read it and put it down. So
Yeah.
So without further ado, let's dig into your blog and maybe some background on the case first.
Yeah, so this, as our viewers might know, this involves a case out of Mississippi known as Dobbs versus Jackson Women's Health Organization. So here, the state of Mississippi has banned abortions after 15 weeks gestation. And what's interesting about this case is, you know, they won in the Fifth Circuit and it was appealed back in 2020. And it kind of just got bounced from conference to conference at the court. And of course, back in at that time, we didn't have Amy Coney Barrett on the bench yet.
And when you say conference, maybe for the layperson, this means that the Supreme Court justices got together and looked at cert cases where people wanted them to review it, and they just didn't make a decision.
Right. So they have a pile of petitions before them asking to review their cases, and they're deciding which cases to take and which not to case. So it bounced from that. They just kept saying, let's do it next week, let's do it next month, and things like that for over a year. So it wasn't granted until almost a year later. And of course, when it was granted, we knew why, because they wanted to overturn Roe versus Wade.
So we knew this decision in the Dobbs case would be bad, but we didn't know just how bad, whether it might be incremental or they would overturn Roe this year. I mean, the prognostications by the experts have been that Roe will be, over by its 50th anniversary next year. So but tell us more about this.
Yeah, so we know that there are at least 5 votes on the Supreme Court to overturn it. So we have Justices Samuel Alito, who drafted the opinion, and Justices Clarence Thomas and Neil Gorsuch, Brett Kavanaugh, and the newest Justice Amy Barrett. So while we know that it's bad, we also need to recognize that it's a draft. So it's just a draft opinion. It's going to go through multiple drafts and may not exactly look the same when the final decision comes down later this summer.
Yeah, I mean, that's important for people to recognize.
Yes.
You're going to have to go through this all over again.
Right. So we don't know what the final version is going to look like, but we do know that the court is poised to roll back the constitutional right to abortion in this country. And to my knowledge, that's the first time the court has ever actually taken away a constitutional right.
Yes. I mean, it's horrifying. So you wrote this blog, 5 Things to Know About the Leaked Opinion, and you went through 5 main points that you think people should take away from this.
Yeah, especially when I was reading the decision, what I really wanted to do was figure out what this decision meant for our members and free
Our
thinkers
cause.
right on our cause.
State church.
You know, abortion, we've always said abortion is a state church issue. But as a lawyer, we always want to see what the ramifications are for other cases. So what is our future litigation going to look like? And so I came away with these 5 main takeaways. First, abortion isn't mentioned in the Constitution, so Alito concludes it's not a right. Second, the role of stare decisis is not as prominent as it once was.
And stare decisis means?
It means that courts should follow
Precedent
and prior cases. And then there's going to be a new standard for any abortion laws that are enacted by states. That's the third thing. The fourth thing would be that state church issues are most definitely threatened here because of the language that Alito uses in this opinion. And lastly, the Supreme Court's broken. We've talked about this a lot on the show too, and it needs to be reformed now.
Yes, it certainly does. And FFRF has been very vocal, showing leadership on this, and I think the public is now kind of catching up. There was a lot of shock, and I guess people weren't paying attention. So
Yes.
let's go through these one by one. The first case you've made is that Alito claims abortion is no longer a constitutional right because it isn't in the Constitution, and how does Alito get there?
Yeah. So obviously the Constitution lays out rights for Americans. The Bill of Rights has these enumerated rights that everybody knows, like the right to free speech, free press, freedom of religion, freedom from religion, things like that. But the Constitution also gives us rights that aren't specifically mentioned. There are certain rights that are gleaned from other provisions of the Constitution, including the 14th Amendment, rights to liberty and to life.
And also part of the Fourth Amendment, right to privacy.
Right. And these implicit rights are guaranteed only if they're deeply rooted in our history and traditions.
That's what Alito is saying.
Yes. So to figure out if abortion is deeply rooted in our history and traditions, he has to make this historical inquiry. And so that's what he does. He starts this long historical inquiry into the history of abortion in our law.
So in your blog, you repeated a comment that we have liked to make a lot at the Freedom from Religion Foundation, that bad history makes bad law. And that is what we are seeing with Alito. Do you want to elaborate a bit?
Yeah. So when he starts his historical inquiry, he spends almost 10 pages going through the history of abortion. And he actually dates it back to the 13th century in England because he's looking at the common law.
And that's why the Saturday Night Live had that funny skit, ridiculous skit.
Yes, it was a great skit.
Yeah.
But yeah, so he's citing treatises that were drafted by people in the 13th century. Notably, he talks about Sir Matthew Hale, who is a jurist from the 17th century, well known for his mistreatment of women. So he is the one who really kind of came up with the idea of the marital rape exemption. He, tried women for witchcraft and things like that.
And sentenced them to death.
Yeah, and sentenced them to death.
So this is Alito's touchstone.
Yes. So he cites to that. And then he goes into talking about how during the colonial period and at the founding, abortion was a crime in many places. And he details that through 1973 when Roe was decided. In fact, at the founding or at the adoption of the 14th Amendment, he mentions that 3/4 of the states didn't have or had abortion as a crime.
So we're showing on the screen this quote, and would you like me to read this one?
Yeah.
So here he says, until
opinion.
the latter part of the 20th century, there was no support in American law for a constitutional right to obtain an abortion. Zero. None. No state constitutional provisions had recognized such a right. No federal or state court had recognized such a right, nor had any scholarly treatise of which we are aware. Well, first of all, Reuters did a news story talking about the nuances of this, and there was an amicus brief that he totally ignored about how quickening used to be a misdemeanor if you aborted after quickening, and then gradually they would started to criminalize abortion rights. But even the Catholic Church didn't consider it a crime until I think it was that 1868. For about 3 centuries, they weren't even worried about abortion. So he kind of glosses over that entirely, doesn't he?
Yes, yes. I mean, he's definitely cherry picking his history here.
And then the other thing is that this was women didn't have any role, any rights, any vote. We weren't on any juries. We weren't any judges. We didn't exist legally. We were, classed with children. So these laws were all developed without the people affected.
Well, and that's the interesting point, too. So later on in the decision, he talks about the role of women in this and in the political process. And he wholly ignores all of what you just said, where, women didn't have the right to vote. We weren't allowed to do a lot of things.
We weren't even allowed into universities until it started in about what I think Oberlin was 1830, and the rest gradually around the time of the Civil War.
Right.
And later.
Yeah.
I mean, come on.
He ignores all of that and then actually has a part of the opinion that I just laughed out loud at, which was that women in this country have a lot of political power. And so what is going to happen after Roe v. Wade gets overturned is that it'll revert back to the states. And so women can find this right in the legislature.
And two-thirds of our state legislatures are men.
Right. But he says, he doesn't point that out either, but he also says that women vote more than men and cites to some recent elections where women were the majority of the voters.
This is like no understanding of the legacy of patriarchy and sexism and being second-class citizens for how many years. There's no history there.
Yeah.
It claims this is based on history.
Yep. No. So
you can see why I had to stop reading.
Right. It gets very frustrating, and some of it is laughable because it's just absurd. But like I said, he notes that at the time of the adoption of the 14th Amendment, 3/4 of the states has abortion as a crime. And so then he concludes that all of this history leads to, quote, the inescapable conclusion that a right to abortion is not deeply rooted in our nation's history and traditions.
So he essentially says that if this wasn't recognized at the founding or the adoption of the 14th Amendment after the Civil War, then it's not a constitutional right. Mm-hmm. This makes the part where bad history does make for bad laws. And, I guess that I think you address this later, but there are all kinds of things that are not mentioned by name in the Constitution. It was broadly written by founders who had the presence of mind to know they wanted something that would adapt a living Constitution. And of course, Scalia and his heirs on the Supreme Court believe in a dead Constitution. This is the problem.
Right, right.
So, then what's the second point?
So the next point that I wanted everyone to take away is the role of stare decisis. And what that means is that it is this principle that we use in our legal system where, stare decisis is Latin for to stand by things that are already decided. And it's this principle that our legal system is going to base its decisions on prior decisions. The idea is that
continuity of
law. We're going to have stability in the law because people who are going before the courts, the judges, the lawyers, and the litigants, everybody knows what the rules are. And if they're going to overturn any precedent, they're going to do that very rarely and when there are huge reasons to do so.
Like the Dred Scott decision.
Yes, yes. And so this is a main argument in the case. It's one that we're relying heavily on if you're for the abortion rights side of things, because Roe and Casey have been the law of the land for decades. Roe's been there for nearly 50 years, as you say, and Casey reaffirmed that right.
And the Griswold decision on contraception was, I think, 1965.
In the 60s, yes. So Alito has to address this issue of stare decisis. If you're going to overturn a huge precedent like that, you have to have some reasons. And so he's going to take a look at why we would do that. But he says that the principle of stare decisis is actually the weakest when we are interpreting a constitutional right. So he's already setting it up that, like, it's not that big of a deal when we're looking at this. And then he...
I mean, that doesn't make any sense.
Yeah.
Because the Supreme Court deals with what's constitutional. So he's just saying then there's no stare decisis.
Yeah, pretty much.
It's the Wild West.
He also then goes to a 5-factor test that will decide if you should overturn something. And all of the factors are listed in the decision, and he goes through them one by one. But one of the things that I think everybody has sort of seen in the news and has been talked about a lot is just that you can overturn a precedent if it's egregiously wrong. And that...
Well, I mean, in a way that is true.
It is true, yes. And so then he brings up these cases that we all know, like Brown versus Board of Education, repudiating segregation, or separate but equal. So he takes these big cases and he basically says, we're just like them. Like we're taking something that was egregiously wrong from the start and should have never been the law, and we're going to overturn it because it was egregiously wrong. And he also mentions that it's egregiously wrong from the start, and also if there's an unworkable test. So he's saying that the tests that Roe and Casey lay out for abortion are unworkable.
Well, viability was one of them.
Yes.
In Roe, and then Casey was
the undue burden.
No undue burden.
Right. Undue burden standard. And he says that those tests just have led to chaos and confusion.
Well, he has seen nothing yet, let me tell you. If they overturn Roe versus Wade, it will be so confusing, so chaotic, so much suffering, so much inequity.
Yeah.
I mean, he's fooling himself.
Yeah. I mean, he's fooling himself a lot. I mean, some of the stuff that he talks about in this decision is just so ironic and really rich coming from him based on some other decisions that he has made. So there's a section when he's talking about this idea of a broader liberty, and he talks about the meaning of life and, how everybody is free to believe what they want to. They just can't act in accordance to that. And we actually have a clip. It's showing right now. I don't know if you can read that one.
He says, while individuals are certainly free to think and to say what they wish about existence, meaning, the universe, and the mystery of human life, they are not always free to act in accordance with those thoughts. Well,
yeah, it's really rich because he also happens to be the author of the Hobby Lobby decision, which you may recall came down a couple of years ago. And that is the case where employers were allowed to block employees' access to birth control.
that if they thought wrongly, for example, that the IUD was an abortifacient, they could stick their noses in their women's employees' in health insurance and say this can't be paid for.
Right.
And then of course the Supreme Court has basically gutted women's rights since then for Obamacare, for the government to pick it up.
So in that case, it's okay for them to act out on their beliefs.
And also, did he ever talk about religion and when life begins?
He did. He actually did talk about that. But the word religion is actually pretty absent from the opinion. He talks a lot more about morality and things like that. But one thing I wanted to bring up before we get into that discussion is also the idea of the Ninth Amendment.
Yes.
That's been coming up a lot too in the news since this opinion was drafted. And the Ninth Amendment says specifically that the enumeration of certain rights in the Constitution doesn't foreclose any other rights. The Bill of Rights, of course, didn't lay out all of our rights, and so that's why we have the Ninth Amendment.
And he does he even mention the Ninth Amendment?
He does in passing. I mean, he kind of like puts them, I would have to go back and look at the opinion itself again, but I do remember there's a paragraph where he just kind of throws in all of these all of these other amendments, and says, the Fourth and the Ninth and everything that kind of like comes together and gives us the right to privacy, that doesn't matter really, because we're also dealing with the special, unique case of an abortion, which involves the killing of another human being. So
he's accepting the religious definition of life here without necessarily saying it.
That's right.
So he's going to impose his views on everybody else.
Right.
So I guess what's the next point we should know about
So
this
we were
decision?
just talking about the role of stare decisis being really diminished. And so the next point is, if he has decided that abortion is not a right that is in the Constitution and we are overruling precedent, we need to know what to do with these laws moving forward. So because it's not a fundamental right in his leaked opinion, then we need to figure out what level of scrutiny to give any laws that states pass about abortion rights if they're challenged. And so right now, as a fundamental right, you're going to be afforded as a litigant the highest standard of review, known as strict scrutiny. But if it's not a fundamental right and it's not protected by the Constitution, then you're going to get what's known as rational basis review. And that's the lowest form of scrutiny that can be applied to a challenge. And it means basically that the government just has to show that there is a rational basis for the statute or the government action. It just has to be related to a legitimate government purpose. And this is the standard.
In other words, they could say reproductive health is a legitimate governmental interest.
Right. Or the reverse. They could say that protecting the life of the unborn is a legitimate government purpose. I mean, this is the standard really where the government, the legislature, is given a lot of deference. These laws, if they're challenged under rational basis review, they are very, very rarely overturned. Very rarely.
Because the rational basis to the layperson sounds rational.
Right.
But that's not a good thing.
Right. And so in this part of the decision, when he's talking about the new standard for abortion laws that are enacted by states, he then finally discusses the Mississippi state law. And here is where he says that the state of Mississippi had these legitimate reasons to ban abortion at 15 weeks. They had put forth evidence that, the legislature wanted to protect the life of the unborn, that they thought the medical procedure of a D&E was barbaric, and that they thought the procedures are demeaning to the doctors that perform them. And he says all of those are legitimate reasons. And so the state statute
the doctors
is
who were among the plaintiffs in the case,
That's right.
were demeaned, and so it's all for their good.
Right. But then to get back to your question about religion being in the case, he does not mention it, but we did have Justice Sonia Sotomayor mention it in oral argument,
Yes.
because it's very prevalent there. And in a clip that we're about to play for you, she is talking to the Mississippi Solicitor General and asks him pretty directly if this is a religious view. We can go ahead and play that.
How is your interest anything but a religious view? The issue of when life begins has been hotly debated by philosophers since the beginning of time. It's still debated in religions. So when you say this is the only right that takes away from the state the ability to protect the life, that's a religious view, isn't it? Because it assumes that a fetus is life at when? You're not drawing when do you suggest we begin that life?
Your Honor, aside from
putting it aside from religion.
So, do we have a second clip of her?
We do, but I'll just mention about this clip. So he doesn't really, the Solicitor General doesn't really mention or answer her question about whether it's a religious view, and they kind of shift to sort of the scientific aspect of it. But Alito's opinion doesn't answer that question either. And I'm not sure we're going to get an answer to that, but
It's the big elephant in the room here that never got addressed in Roe either.
Yes. Yes. And so what's also interesting about this case is the biggest part, the biggest thing about this case is its ramifications, obviously, for state-church separation and those issues. And some of the ideas that he's talking about in the decision are really not ones that are foreign to the practicing state church attorney. So he talks a lot, again, about history and tradition being something that they need to take a look at. And of course, we've heard that type of thing all the time. In our cases,
Yes.
the use of history to analyze cases has been used in Establishment Clause cases for decades.
And it's an outlier,
Yes.
like in the Marsh versus Chambers case, which was saying it was okay to pay clergy to come in and do prayers at the state legislature.
Yeah.
They used this stupid rule, and then they kind of dropped it. We never heard from it again until the Greece case.
Yep.
That said that city councils could pray, and if they were predominantly Christian, that was okay, but with the silver lining that you had to let maybe atheists and Satanists and so on do something, depending on the circumstances. But so we've been dealing with this very bad history test.
Yes.
But now you're saying he's opening the doors.
Yes. I mean, he's saying a lot of the same things in this leaked opinion that we've been hearing about in our cases for decades. And so it's really opening up this idea of history and tradition to a lot of other civil rights. The other thing that he talks about...
First of all, if you have a history or tradition of racism, of sexism, of denial of rights, then that's okay?
I mean, that's the open question that we'll be litigating soon. Yeah. So one of the other things that I thought was interesting about the case is that he talks a lot about the unworkability of these tests. I mentioned that before, and it was very reminiscent of a decision that came down earlier that day that the leaked opinion came down, the Boston City Hall case that I had mentioned at the top of the show. So in that case, Justice Gorsuch actually railed on the Lemon test, which is the test that we use for evaluating Establishment Clause decisions. And he really just talked a lot about how that case and that standard that we use, the Lemon test, is really unworkable too. And so you're getting a lot of these same themes from all of the justices about history and tradition and unworkability and things like that.
They're undoing everything good that ever happened to Supreme Court decisions since the 60s is what I take away.
Yeah.
So what does this mean for other civil rights that we care about and that are related to state church or adjacent to this area? Things like contraception, same-sex marriage, and so on.
Yeah, so, well, it's interesting that you bring that up because Alito does try to assure us that those rights are fine, and he actually writes this in the opinion. He writes, "And to ensure that our decision is not misunderstood or mischaracterized, we emphasize that our decision concerns the constitutional right to abortion and no other right. Nothing in this opinion should be understood to cast doubt on precedents that do not concern abortion."
Abortion, that's very concerning language when we talk about contraception.
Yes.
But this doesn't make any sense because Alito voted against marriage equality in the Obergefell decision.
Yeah.
That is very much endangered.
Yeah, absolutely. So, I mean, his decision here, even though he says that, he's playing lip service, we can't take him at his word because this decision provides a roadmap for overturning some of those rights that are also not rooted in history. So like the right to birth control, as you mentioned, same-sex marriage, the right to sexual intimacy, the right to interracial marriage, all of those.
I can't remember, was that a 67 case, the Loving case? Was
Yeah.
even after Griswold, the contraception case.
Yes. So all of those
These
rights
are-
that we just mentioned are not enumerated. They're not found in the Constitution explicitly.
But we feel they are. He's saying they're
right,
not.
and they are,
The broadness of the Constitution he's ignoring.
Right.
He's ignoring that the founders were wiser than he was. And
Right.
it's that Scalia interpretation of the Constitution that it's dead. They look at the Constitution like Bible literalists.
Right. And how could you not think that those are aren't on the chopping block when you look at the decision and he said, well, in our history, abortion was a crime. And in all of those things that we just mentioned, all of those rights we just mentioned, like same-sex marriage, the right to sexual intimacy, contraception, all of those were also outlawed at some point during our history.
And based on the Fourth Amendment and the 14th Amendment.
Right.
So how could they not be endangered?
Right.
He's totally disingenuous. Don't believe a word he's saying about this.
Exactly. But also, he actually wrote about the Obergefell decision that was allowing same-sex marriage to go forward across the country in an opinion well, it wasn't an opinion. It was a statement from the court when they decided not to take on a case that was filed by Kim Davis, who was that clerk in Kentucky who was refusing to issue marriage licenses. And so he writes in this statement, this is what he said about the Obergefell decision: by choosing to privilege a novel constitutional right over the religious liberty interests explicitly protected in the First Amendment, and by doing so undemocratically, the court has created a problem that only it can fix. Until then, Obergefell will continue to have ruinous consequences for religious liberty.
So I mean, it's so obvious he's laying his cards on the table, but he's pretending he's not.
Yeah.
So every draft opinion, this draft opinion really then does put every civil right on the chopping block, as you say. And you end your blog noting that the court is broken and saying that we must reform it now. And of course, we've been calling for court reform for years now. And let's talk just a little bit more about what that involves.
Right. Well, at first, I think that this is probably a great place for us to play the second clip that we pulled from the Dobbs oral argument, where Justice Sotomayor talks about just what this means for the court. Let's go ahead and play that.
Will this institution survive the stench that this creates in the public perception that the Constitution and its reading are just political acts?
So she and Breyer in particular, at that was that the Dobbs decision, or was that the Dobbs hearing?
This is at the Dobbs oral argument.
They were. Breyer is a very unemotional. He was so upset. Good for him. You know, the outgoing justice, talking about how nothing has changed with the law, the need since Roe was adopted, since Casey amended it slightly. The only thing that's changed is the composition of the court.
And that's also like why what's interesting about this case is when they filed for cert in 2020, the state was actually telling the court, you can take this case and you don't have to overturn Roe and you don't have to overturn Casey. You can say, like, rule in our favor without doing that. But then once the composition of the court changed,
with Amy Coney Barrett,
right,
replacing
then
Justice
in 2021, when it was taken and they filed their merits brief, they actually changed the argument and said you have to overrule Roe and Casey. And of course, we know that that's why they took the case. That's why these justices, Kavanaugh, Gorsuch, and Barrett, were put there to do this.
They were put there by Trump, who, as candidate, promised that he would appoint justices who would overturn Roe versus Wade.
Right.
And it looks like he's succeeding.
Yep.
And I do have to reiterate that really 2 of these seats are stolen. Justice Gorsuch was put on by Trump after Obama was denied the right to have his nomination hearing for Merrick Garland.
Yeah.
If Merrick Garland was on the court, as he should be, this wouldn't be happening.
Right.
Because Scalia died in February, and he nominated
in early March.
And it was an election year, a presidential election year. And then, lo and behold, when Justice Ginsburg died in September of an election year, presidential election year, they rushed her through in 60 days?
Yeah.
In the middle of, I think half of the nation had already voted, at least 60 million people who were voting because of, we don't just vote on election day.
Yes.
And so these are stolen seats. This is unfair. There's no way to remedy this without appointing at least 2 more justices. And one of the bills that we supported is by Mondaire Jones and Jerry Nadler that calls for 4 seats.
Yes.
And I think the rationale there is that we have 13 appellate districts. Why not have 13 justices? Because that was historically what they used to do.
Right, and the number of justices has changed throughout our history, and it makes sense. I mean, the federal court docket is full. Even if you are looking at just the lower federal courts, especially the district courts, I mean, some cases, especially some of our cases, they will languish at the district level for years because we just simply don't have enough judges to go through all of the cases that are being filed.
I think they haven't expanded the district court and appellate, for 20 years or more?
Right.
And our population is moving up, and so this shouldn't even be controversial. It's just necessary.
Right.
The Supreme Court, admittedly, might be controversial.
Right. So, I mean, I think that there should be some political will to at least transform some of the lower federal courts, which really are the courts that are going to deal more directly with people's everyday rights. And they just handle a lot more cases. I mean, obviously, the Supreme Court's important because they're going to be providing direction to these lower federal courts. But, I mean, there's just so many reasons right now for court reform, aside from the stolen seats and how the Supreme Court is broken, just practically the amount of cases that are going through. But then there's also a lot of ethical issues that we have. Obviously, there are codes of judicial conduct for lower court judges, but there's not that for the Supreme Court. And that is kind of absurd to know that they can do whatever they want. I mean, the right for recusal.
They can decide whether to recuse themselves.
Right, they decide themselves.
Right.
And that just doesn't seem okay or fair or something that we should have as part of our legal system.
Well,
so a lot of these,
particularly with Justice Clarence Thomas and his wife Ginny Thomas, with the revelations that she was in direct cahoots with the White House saying the election was stolen. And then when he had to vote on that issue, he never disclosed this conflict. He was the sole dissent.
Yeah.
So on releasing documents from the White House. So, I mean, wow, this stinks.
It does.
There's
it really
a stench,
does.
as Sotomayor said.
It really does. And, I think if you had asked me 2 years ago, is there any sort of political will to reform the court, I would have said no. But we're still going to call for it because we believe that it should be reformed. And I agree with you. I think one of the biggest injustices that ever happened is that Obama didn't get to nominate Garland, and he didn't even get a hearing. He didn't even get a hearing.
I also feel that was very racist. He was the first black president to be disrespected in this manner.
Yes. And so, but now with all of these things coming out about Justice Thomas, and, we see, our eyes are open and we can see the world and we see all of these civil rights unraveling, and all of our worst fears from like 2016 are coming true. I think there might be a little bit more push to reform it, at least in terms of ethics, if not expanding the number of justices on the bench or to expand the lower federal court.
I can say that more than a year ago, when I was part of a coalition talking confidentially about court reform, I was the one who spoke up and said, we cannot hold Roe versus Wade with this court. It's, this is basic. I mean, and here we are. I mean, I was stating the obvious, but It had to be said. And I think that I should also say something that we have said before on this program, that the Freedom from Religion Foundation would not exist were it not for the abortion issue, because it is what opened my mother's eyes to the harm of religion and government as a Wisconsin and national figure, to work to, at that time, decriminalize abortion rights. And she was referring women for abortions to Mexico City, and started the Women's Medical Fund to fly women out of Wisconsin when we couldn't get them here to New York. I mean, we've lived through this already, and it is a nightmare when women cannot get abortion care. And it is a religious issue, and it's all about enforcing your dogma about when personhood begins on other people who disagree. And it's going to be it's just a nightmare for our country. And this is just the beginning. So we are really facing a very serious assault on our republic. It's not going to stop here.
Oh, absolutely.
Everybody is already rallying. I wish we'd shown some of the pictures from our rallies in Madison, and the Freedom from Religion Foundation has gotten a lot of public photos taken in the newspapers and so on. Our banner's been there. People know that we're there, but it really is a state church issue. So many of the rally signs are about religion. So
yeah. And it absolutely is not going to stop there. I mean, we know that they've never wanted to just stop at abortion, even though it's this unique issue that Alito keeps talking about. We already know, like we had mentioned earlier, that the writing's on the wall. They want to come after these other rights.
Including the contraception that keeps people from needing abortion care.
Exactly. But also, I mean, I think it's infuriating that they could come after same-sex marriage. But if they're going after same-sex marriage, I mean, they can also go for interracial marriage. And just any sort of the fundamental right to marry is not in the Constitution.
Right.
So
we do have some questions,
We do have questions. So the first one comes from Jen. Do you think the timing of this shortage of baby formula was rather ominous, since at the same time we couldn't feed our babies, the Supreme Court is trying to have us birth more of them?
Well, you're right that she's right that the anti-abortion movement cares about human life all the way from conception to birth, as the old saw goes, and we're a country that has so few rights for mothers and children compared to other Western countries.
Yeah.
So, yep, we're going to be in trouble.
Mm-hmm. So Dan Cancrow asks, if the Constitution wasn't meant to cover things not explicitly mentioned, then what's the point of a Supreme Court at all? And I think that's something that you kind of mentioned at the beginning of the show, too, when we were talking about when can you overturn things, and you were like, well, if it's at its weakest when we are interpreting the Constitution, then what's the point?
Right.
And it's a very good question, and I think something that they're also grappling with as they, especially Chief Justice Roberts has to deal with the fact that his legacy is going to have all of this associated with it.
And we have seen, since Amy Coney Barrett was appointed to the court, we've seen the huge drop in approval ratings of the court, trust in the courts. What is it, at the lowest, 40% or something? Mm-hmm. I mean, this is something that, what really infuriated me about, among the many things that Alito wrote in his draft, was that he basically said, we mustn't pay any attention to the response to this decision. It doesn't matter what the public thinks. I mean, this total dismissal of what the public thinks of the court.
Yeah. So Karen Hubbs writes, with Alito's logic on abortion, does he think only white land-owning men should get to vote? Slavery was also a long-standing norm. Is he going to bring that back,
It was in the Constitution, of course.
Yeah.
And the Native Americans and enslaved black people counted as, 2/3 or 3/5 persons. Mm-hmm. That was in the Constitution.
Yeah.
Do we go back to that?
I mean, I think that is something that everything. I mean, like if our barometer is the adoption of the 14th Amendment, there's a lot of things that we could lose and roll back to. I know that I think it was the night after the decision came down, there was something that was on Twitter. It was kind of funny. It was just like, well, women didn't have the right to enter into contracts until the 70s. And so I am now like forgiven of all of my credit card debt because I wasn't allowed to have a credit card until before then, and student loan debt and things like that. And so I guess it's nice that we can kind of joke about that. But I mean, really, we can ask these questions, and I mean, legitimately, they're good questions to ask because I have no idea what they're going to roll back next. And of course, people are going to say it's absurd. We're not bringing back slavery, but
well, we're bringing back reproductive slavery.
Right.
Sorry.
Exactly.
I mean, if you don't have control of your own body for 9 months and then you have to be responsible for somebody for 20 years after that, taking care of them and feeding them and educating them, I mean, that's a form of servitude, I think.
Yeah, yeah. So this is a good question to end with. Carrie May says, do you think Judge Jackson, Ketanji Brown Jackson, being confirmed is one of the rare glimmers of hope for our constitutional rights?
Well, of course, she's replacing Breyer, who's in the minority. He's liberal.
Yes.
So her vote isn't going to make any difference. Her perspective, her dissents, her jockeying with people, you know, that is very important.
Yeah.
I mean, it will change things for the better on the court. It'll be more representative than Breyer was an old white guy. But in terms of the actual legal changes, not so much.
Yeah, I mean, she's not shifting anything on the court. She's still going to be in the minority and in the dissent, as you say. But really, you hit the nail on the head there, where right now we're in this area where what we're really vying for are just really strong dissents, because we know from legal history and precedent that these dissents will eventually become law and become a majority opinions. And so we really want to get strong opinions like the ones that we get from Sonia Sotomayor. Yes. And we really want to just have those so when we get to a place where the court isn't so abysmal, they have some of these dissents to draw on. So I hope that she writes some of the things that we've seen from Sotomayor.
And I think she will, and I think it will make a huge difference in more representation on the court and in those dissents. But from a practical point of view, being able to save the court, sorry.
Right.
She needs more help. She needs some additional people.
She does need additional people. But, I mean, you're right. She's inspiring. Yes. And we have a lot of women attorneys and black women attorneys who are
little
celebrating
black children and girls.
Right.
They can see themselves on the court. And we've seen how important Sonia Sotomayor is.
Yes.
As a Puerto Rican heritage person, Hispanic. She's been so vital on the court. So good things will come from it. Yeah. But it won't make a difference in saving Roe versus Wade.
Right, right. And she's on the court for life. So, I mean, maybe she will see herself in the majority someday.
Or we can get some court reforms sooner rather than later. But speaking of dissents, we are ending this show, this conversation, but now we want to do some previews. And one of them is that today a very important new podcast just dropped called We Dissent.
Yes.
So tell us more about that.
Yes, so We Dissent is our new podcast. It launches today, and I'm so very excited about it. It is a podcast with 3 other women attorneys at the major secular organizations here in the United States. I'm joined with attorney Liz Cavell from Freedom from Religion Foundation here, Allison Gill from American Atheists, and Monica Miller from the American Humanist Association. So in this podcast, we talk about religious liberty cases at the Supreme Court and the work that we do to keep state church separate. So we really wanted to do a podcast that featured women lawyers in this line of work because often their voices are not as amplified as they should be. And we really recognize that our organizations have been founded and are run by women. And we really wanted to acknowledge that and highlight that there's a lot of really powerful secular women doing a lot of really great work in this space. So as I said, it drops today. Our first episode is on the Carson v. Macon case that's pending before the Supreme Court.
And that's that involves vouchers in Maine.
Yes, yes. So the first episode was published today, this morning, so you can find it wherever you find your podcasts, but you can also go to our website, we-dissent.org.
So very exciting and very timely. And we also want you to be sure to check out FFRF's broadcast TV program, Free Thought Matters, this Sunday. And it's in 13 major cities, or the new episodes drop every Thursday on FFRF's YouTube channel. And we're really pleased this week, and I know Rebecca's very excited, that we interviewed TV star and non-believer John Huertas. And he just finished the concluding season for the hit show, This Is Us. And you may not have realized that he's a freethinker, and he talks a lot about that. Here's a little teaser.
Non-theist or humanist is usually what I call myself. I kind of feel that, religion gives people an out so they don't take responsibility for the good that they do in their lives, to cause good in their lives, or when something, not so good happens in their lives, that they can blame it on something else other than maybe their own actions or just, chance. I like to feel that humans, we are better than we give ourselves credit for.
Very excited about that show. This Is Us is one of my favorite shows. Also on this Thursday's Free Thought Radio, Dan and Annie Laurie talk with Samuel Perry about the new book he's co-written, The Flag and the Cross, White Christian Nationalism and the Threat to American Democracy, particularly pertinent after the racist motivated massacre in Buffalo on Sunday by a white Christian nationalist. So that concludes Ask an Atheist for this week. Thank you so much for joining us.
And if you want more information about the Freedom from Religion Foundation, check us out at ffrf.org. See you next week on Ask an Atheist.